confidential business information, and the second being Benicia's emergency response plan. So first I'm going to turn it over to Brad Hogan, who's going to provide a brief overview of some of the legal aspects, followed by Benicia's fire chief, Jim Leiden, to provide information on the city's emergency response plan.
Good evening, Mr. Chair, members of the Commission. As Amy said, I'm going to talk about two things: preemption and confidential business information. The preemption issue is this: there's certain aspects of this project that have impacts that arise from the operation of railroads. Those impacts are potential risk of a release of crude oil, environmental damage, possible fire and explosion that could damage property and injure people. And the second risk is, or the second impact rather, is the impact on air quality from locomotive emissions. So the question is, the simple question is, what, if anything, can the city do to mitigate those impacts under CEQA, or otherwise reduce those impacts under its police powers or some other law? And the answer is there's nothing that the city can do. And that's because of the Interstate Commerce Commission Termination Act, which is a federal law. And under that law, the Surface Transportation Board has exclusive jurisdiction to regulate the transportation of crude oil and anything else by rail. And among the other things that are preempted are local laws that impose permitting requirements, sometimes referred to as pre-clearance requirements, and CEQA is one of those. That's basically any time a local agency or a state agency would want to say to a railroad, if you want to do that, you have to get a permit from us and we're going to regulate that, okay? And under the ICCTA, the railroads do not need to get permission to do anything from cities, okay? It's that simple. This is very well established in court decisions in the Ninth Circuit Court of Appeals, which is the circuit court that applies in California. Other Circuit Court of Appeal decisions, decisions by the Surface Transportation Board as part of its administrative rulemaking and administrative determination process. And last year, even from the California Attorney General, Kamala Harris, she filed a brief with an appellate court that argued very strenuously that CEQA is preempted by the ICCTA. And Attorney General Harris, I'm sure everyone knows, is a very strong proponent of a vigorous enforcement and implementation of CEQA. So if she says it's preempted, you can bet it's preempted. So what does this mean? Again, just to reiterate, let's say the city wanted to say, we're concerned about the risks of a spill and we want to reduce air pollution, so Valero, we're going to approve your project, but only with a condition that you only run one train in and out a day instead of two trains in and out a day. You would be preempted from doing that. The city does not have the authority to do that. The city does not have the authority to adopt a regulation that limits the emissions from locomotives. That's completely preempted. The city can't say, well, you have to use these tank car standards instead of these other tank car standards. Okay, so if there's any questions on that, the answer is pretty simple. The analysis is somewhat complicated, perhaps, but the answer is pretty simple. The second issue is confidential business information. Under CEQA, there's a specific provision under CEQA that says that an applicant for a permit in connection with the environmental review can submit information that is confidential business information that has some kind of competitive value and designate that as such, and the city is prohibited under CEQA from disclosing that information. And the definition of confidential business information is very broad. Basically, it's any information that has competitive value. So it could be a process that isn't patented, a particular formula, customer lists, supplier lists, and so on. I mean, I couldn't possibly sit here and recite all the different types of information that could properly be considered confidential business information. But for our purposes here, the city has requested from Valero a great deal of information in connection with this environmental process, and they have been very forthcoming. There has been a very small percentage of the information that they've submitted. that they have designated as confidential business information. We, the city, said, you know, we need to give certain information to our experts to be absolutely certain about our conclusions. So we understand that this type of information is business confidential, or could be business confidential, and they designated a very small portion of it and gave it to us, and we gave it to our experts. And the experts looked at that to make sure that, you know, they had all the relevant information they needed. And there's basically two types of information. Excuse me. The first type of information is basically what particular crude oils does Valero intend to purchase once the project is up and running, assuming the project is approved. Valero has publicly said only that it intends to purchase light sweet crudes. There's a table in the EIR that lists about 40 North American crude oils that potentially Valero could buy. And there's no condition or requirement that they buy any particular one. And whatever crudes they start to buy, that could change over time. So for purposes of the environmental analysis, we've assumed that they could buy any number of those, any one particular one or any combination or whatever. But in their public version of their application to the Bay Area Air Quality Management District, they stated that they intended to buy light sweet crudes, similar to ANS, that's Alaskan North Slope lookalikes. Well, if you look at that list, there's a bunch of them that fall within the category of light sweet crudes. There is a confidential version of that letter to the Bay Area AQMD that identifies one or more specific crudes that Valero intends to purchase. And they have designated that information to be confidential. The Bay Area AQMD has protected that information. The city has protected that information. The city would violate CEQA if it doesn't protect that information because it has competitive value. If Valero's competitors knew where they intended to get their crude oil from, they could kind of outfox Valero by locking down contracts from that supplier or bidding up the price of that particular crude and so on. So they could wreak havoc with Valero's business strategy. Or they could simply steal the idea. They could say, oh, that's why Valero's making a lot of money, because they're using that combination. So I'm going to try that combination too. Okay, so that's quite clearly, and again, the Bay Area AQMD recognizes the confidential nature of that information, as does the U.S. Environmental Protection Agency. In the EIR, there's a discussion of the EPA's rule on confidential information, and they talk specifically about crude oil feedstocks and how crude oil feedstocks must be considered confidential information. The other general category of confidential information that Valero has designated is the detailed properties of crude oil that it either blends and processes or that it has delivered to the refinery. These are commonly known as assays. They're like, you might think of them as fingerprints of a particular crude. So it would list not only the weight of the crude and the sulfur, but the acidity, the Reid vapor pressure, and so on. And it would be associated with a particular crude, like Cold Lake, let's say. Valero has some information that might, for example, say Cold Lake, you know, that we processed on this particular day had these particular properties. And the reason that's confidential business information is because other refiners and engineers at other refineries can use that information to figure out how Valero is making its crude oil. Making crude oil is a very complicated process. You might think of it, you know, as an analogy. It'd be like a cook, you know, the Gary Denko or whoever. Some famous chef in San Francisco has a very, you know, complex process for how he puts something together. You order, you know, salmon with mushroom and cream sauce. It comes to you, you know it has mushrooms and cream and salmon, but you don't know how he marinated it, what spices he put in, how long he cooked it, and so on. I'm just trying to give a simple kind of analogy for something that's very complex. But basically, if all of these detailed fingerprints of the crude were disclosed to its competitors, that would put Valero at a disadvantage. And finally, and could be the most important point, that the federal regulators and the courts have determined that oil companies can violate the antitrust laws by sharing confidential information about their operations, because that is a way to help them ultimately fix prices. And there have even been some enforcement cases where there was no meeting of the oil companies. It was simply one oil company publicly disclosed the information, the other companies looked at it, and sort of a conspiracy was formed, or at least that was the allegation, simply by the disclosure of the information into the public domain. So that's a final reason why it's important for the city to keep this information confidential, not just to protect Valero, but really to protect the public at the end of the day, to the extent that disclosing this information could facilitate an antitrust violation, which would result in increased oil prices. So, Mr. Chair, members of the Commission, that is all I have to say on that. Be happy to answer any questions.
Okay. Any questions for council?
I do have questions on this topic, but I said that I would defer all my questions until after the public comment. Is this the right time, or I'm willing to wait?
I'll still be here, but I'd be happy to answer any questions right now while it's fresh, either way.
Okay.
Not going anywhere, unfortunately.
The whole question of the actual source of the crude oil that's being purchased. Is there any other natural resource that you can think of where the actual location of something being purchased is considered confidential? Coal, lumber, anything else like that?
I don't know. Not that I know of offhand. I haven't studied any of those. I can tell you I have studied crude oil. Crude oil is very different from lumber. I mean, lumber, you just cut down the tree and chop it up and sell it. I mean, but crude oil, refining crude oil into marketable petroleum products is extremely complex.
Yeah, and I understand that. I'm just talking about the source of where it's coming from. The state Energy Commission says that 85% of all the crude oil coming into California is back in shale. There's numerous references to back in shale in the document.
That couldn't be the case right now.
That's according to the California Energy Commission, right now, 85%.
I don't know how it would get here, because it's
Well,
not
it
being
is-
shipped by rail to California yet. But that's okay. Go
Well,
ahead.
let me go further then. In March, a spokeswoman for Tesoro in Martinez confirmed that Tesoro is receiving 5,000 to 10,000 barrels a day of back in shale. That was in the Contra Costa Times. Phillips Refinery in Rodeo is bringing in tar sands, according to the Contra Costa Times. But most interestingly, not in California, but in Memphis, Tennessee, at the Valero refinery itself, it is widely known and publicized that Valero is using back in shale, and they talk about it openly. Bill Day, who is a spokesman for Valero, described in a Memphis Commercial Appeal report that Valero was using back in shale because of the cost savings, and that Bakken represented 75% of the oil used at the Memphis refinery.
Hang on one second, Commissioner Young. I'm going to interject here because we're getting into some really detailed information that deserves a detailed response.
It is, yes.
But I would like for the staff to complete their presentation, and we still need to get to the public tonight. So we could talk about this for a long time. So are you willing to defer your questions? Okay, thank you. So other questions for staff regarding the process tonight? I understand there are people in the audience who would really like an answer to that question, and we'll get there, but there's plenty of people who came here specifically tonight to speak, and we want to make sure at least we can get started on that process. So, any other questions on process from council? Process, okay. Commissioner Smith.
So you stated that SEQ was preempted, and so as a mitigation measure, we couldn't make any requirements that are under the jurisdiction of the federal government or anything else. When you get to a use permit and conditions of approval, could say, for instance, the use of the tank cars, and the applicant has already stated they'd be using the 1232 tank cars. Could that not be listed as a condition of approval?
It could not.
It could not.
Because it is simply an indirect way of regulating the railroads. And the railroads don't need our permission. They don't need our approval. But such a condition would not be necessary in this case because Valero has committed that it will use the 1232 cars. That's part of the project description.
So because it's stated that that's what they will use, and then somehow they have to use those?
Yeah, well, we can look into enforcement. I don't know if we could get an agreement between Valero and the railroad, for example, that would make them contractually committed to use the 1232 cars. We could do that, for example, but there's no way that the city can require Valero to use a particular rail car.
Okay. Thank you.
Okay,
Can I follow up on that question?
sure.
What if Valero themselves owned the cars and not UP?
Well, actually, Valero does own or lease the cars.
Okay.
UP does not own any of the
But the
cars.
federal preemption of regulation applies to the privately owned rail cars as well?
Yes, because it's all part of the rail operations. Tank car standards, and any aspect of the rail operations, they don't need our permission. So it applies to their own locomotives. It applies to the cars that they carry. They don't need our permission to carry, any particular car. The only permission they need is the Surface Transportation Board and also complying with the regulations of the Pipeline and Hazardous Materials Agency Administration and the Federal Railroad Administration.
One more question, then I'll shut up.
Okay.
I think you said earlier that the city could not ask or require the railroad to use only one delivery a day. That was one of the proposed mitigation measures.
Right.
But that means that they could theoretically bring 3 or 4 cars a day, 3 or 4 train loads a day. Is that true?
As far as imposing conditions on Valero, I suppose we have, yes, we cannot impose any direct limit on the amount of crude, on the transportation of crude. That's right. But as far as Valero's use permit, their project has stipulated that it's only going to be, so many trains a day. It's only going to be the 2 trains a day.
But there'd be no way to enforce that.
I'm sorry?
There'd be no way to enforce that?
Enforce that limit? I'd have to think about that, actually. I'd have to think about that. It's a good